Wow, used the gavel for the first time in 18 months. Welcome everyone to the Judiciary Committee meeting, the first one in person, and we can't figure out how long, quite some time. My name is Carl Rhodes. I'm chair of the committee. With me today are Senators Ocasio and Lee, and others will be joining us later. We have one agenda today. That's the 9:30 agenda. And as noted, this hearing is being streamed live on YouTube. You can find links. Oh, I'm sorry, that wasn't noted. This hearing is being streamed live on YouTube. You can find links to review options for all Senate hearings and meetings on the live and on-demand video page of the legislature's website. If you're interested in seeing the written testimony, you can go to the legislature's website at capitol.hawaii.gov, Capitol with an O. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business on Thursday, the 17th at 9:25 in this room in a video conference, and be sure to wear green. And a public notice will be posted on the legislature's website. Okay, for the people testifying remotely, all testifier audio will be muted and video disabled until it's your turn to testify. We do have a 2-minute time limit on each testifier. If there are temporary technical glitches during your turn to testify, we may have to move on to the next person, but we'll try to figure out the technical part of it and bring it back if we can. We do have your written testimony. Let's see. I think that's it. So first up today, we have Governor's Message 595. This is Patricia Morrissey for consideration and confirmation to the statewide Voters with Special Needs Advisory Committee for a term to expire on June 30th, 2025. First up on GM 590 is Donald Sakamoto. Signed up for Zoom. Can people hear me okay? I can't.
We hear you good, Senator.
Okay, great. Donald Sakamoto?
Not present, Chair.
Not present. In support, Virgil Stinnett, President, National Federation of the Blind of Hawaii. In support, Stephen Miller. In support, Norman Miller. In support, Chris Chong. In support, Peggy Chong. In support, Davey Evelyn. In support, Susan Gashel. In support, Catherine. Oh, okay. And that's all the testimony we have on GM 595. And there's no one to ask questions of. So we'll go ahead and move to the nominee herself, Catherine Keem, if you are here. Oh, there you are.
Good morning.
Go ahead. Good morning. Go ahead and if you'd like to make an opening statement.
I would. I thank you for the privilege to be in front of you this morning. And I am honored to be nominated by the governor and look forward to serving our community for accessible voting, for privacy and independence of all individuals with disabilities, I being one of them, and continue to vote since 1977. So thank you. I'm here for questions this morning.
Very much. Members, questions? Sorry to mispronounce your name. Keim.
It's Keim. It's okay. I knew who you meant, Senator.
I do have. So, what do you hope to accomplish on the statewide Voters with Special Needs Advisory Committee?
I believe one of the key points that I would like to accomplish is establishing a relationship with the Office of Elections so that they can embrace the understanding and technical needs of those of us that are blind and print disabled in particular, so that we can continue to vote privately and independently through accessible options. The technology is present, but if you're not having to use it, I understand completely that they may not understand or have the access to the network that I do and others would on the committee. So we hope to work with the Office of Elections so that they can embrace it and implement it fully in Hawaii.
Okay, thank you very much. Members,
Sure.
Any other questions? If not, thank you so much, Ms. Keim, for being willing to serve. And
You're welcome.
I appreciate you being here this morning.
You're very welcome. Thank you for your time.
We'll go ahead and move on to GM 635. No, I'm sorry. We'll move on to GM 590. Apologies. Find it here. There it is. Okay. This is also for the statewide voters with special needs advisory committee. This is Patricia Morrissey for a term to expire on June 30th, 2025. First up on GM 590 is Rainey Doc Matthews. Good morning.
Good morning. Good morning, Chair Rhodes, Vice Chair, and Senate Committee on Judiciary members. My name is Rainey Doc Matthews. I'm a resident of Hawaii residing on Maui and Wailuku. While I am the newest member on the Maui County Commission on Persons with Disabilities, I am speaking as an individual. While all the candidates are very strong, I want to specifically endorse Dr. Patricia Morrissey. I ascertained from my research on Dr. Morrissey, it appears she understands voting rights are under the umbrella that disability rights are civil rights and is richly embedded. As a 16-year flight attendant, when my career suddenly came to an end by a stroke at age 53 in 2004, I just never dreamed that I would be living in the world of persons with disabilities. In my struggle and fight back with regards to being able to function, and then becoming an active voice for the disability community, especially in the area of voter rights, as I was sorely taken advantage of during my voting in 2016 Super Tuesday. I see that Dr. Morrissey and all that she has, that she seems that she will advocate on behalf of we people with disabilities, especially voting rights. And I'm looking forward to sharing with her with regards to Rev Up, a initiative of the American Association on People with Disabilities. Thank you very much for your time.
Thank you. Next up, Daintry Bartolus, Executive Administrator for State Council on Developmental Disabilities and Support. Louis Erdachik, Executive Director, Hawaii Disability Rights Center and Support. Kuriko Takahashi, PhD, Interim Director for the Center on Disability Studies at Hawaii UCEDD in support. Robert Stoden, Professor Emeritus for testifying as the past Director of Center on Disability Studies, also in support. Sue Burke, President Fuller Lives in support. Kelly Murphy in support. Susan Rocho in support, Special Parent Information Network. Rainey Doc Matthews, we already had. Raphael in support. And that's all the testimony we have on GM 590. Members, any questions for this testifier that was with us this morning? If not, Ms. Morrissey, if you'd like to make an opening statement.
I'm very honored to be being considered for this position, and I think it's a very important one. I think the key thing is to recognize that 1 out of every 4 persons living in Hawaii is a person with a disability. So we're talking about a large group of people. And so it's important that they have access to the voting process. In terms of my past history, the most important thing for you all to know is that I was responsible for implementing the disability provisions in the Help America Vote Act from 2002 to 2008. And that was a nationwide initiative to improve accessibility for people with disabilities. So I have a lot of experience with the issue, and I also have access to a large network of people that are involved and have been involved in making voting accessible. I'd like to make 2 observations about things I think are important. One is that the legislation, although it mentions people with visual and hearing impairments specifically, and also uses the term physically disabled, it doesn't make reference to those with either cognitive or mental disabilities. And I think it's important that those people be included. And I hope that that understanding is a commonly held one among all of us involved in trying to bring this important committee's work to the public's attention and to do what is needed. The second point I'd like to make is that the legislation, although it connects this committee to the Office on Elections, it does not specify specific support in terms of money or staff to help the committee do its work. Now, and obviously for the committee to do its work and to be credible, it needs access to staff and also financial resources. And the third thing I'd like to mention is I think the first step for such a committee would be to do some type of statewide survey of people over 18 with disabilities to see how many people have had either a positive or a negative experience connected to voting. Thank you very much.
Thank you. Members, any questions for Dr. Morrissey? Well, I was going to ask you what you hope to accomplish on the board, but you've already explained that in quite succinctly, so I won't ask that, and we'll go ahead and move on to the next GM. Thank you very much for being here this morning.
Thank you.
Next up is GM 635. This is for Elizabeth Kent for the Commission to Promote Uniform Legislation. It's for a term to expire 6/30/2026. First up on GM 635 is Jill Nagamine, Deputy Attorney General for the AG's office. Good morning.
Good morning, Chair Rhodes and committee members. I'm a Deputy Attorney General, and my written testimony describes the function of the Commission to Promote Uniform Legislation, the CPUL, and lists many of Elizabeth's accomplishments and activities in her services to the CPUL. My main point to this committee is that Elizabeth has demonstrated her dedication and commitment to improving the laws of Hawaii and is a true asset to the CPUL. It has been my personal pleasure to work with her for the last year and a half. On behalf of the Attorney General, I respectfully request you to recommend her for confirmation to another term as a commissioner of the CPUL. Thank you.
Thank you very much. Next is Lonnie Ewart in support, Ken Takayama in support, Ellen Godby Carson in support, Sandra Kunimoto in support, Wayne Tanaka in support, Alexa Fujisi in support, Peter Hamasaki in support, Rhonda in support, Bob Toyofuku in support, Peter Adler, PhD in support, and Stephanie Kendrick for the Hawaiian Humane Society also in support. Members, any questions for Ms. Nagamine? Seeing none, Ms. Kent, would you like to make an opening statement? Go ahead.
Thank you. It's an honor to be nominated, and it's an honor to follow those two amazing women who went before me. Of the 53 states and territories that are part of the Uniform Law Commission, I'm proud to say that Hawaii's delegation is, I believe, one of the strongest. We have committed commissioners who are active on drafting committees, in leadership, and in enactment. We work exceptionally well as a team. Together, we bring diversity of thought to the process, and that's really what the uniform law process is all about. We believe that discussions in which we air different views will lead to better drafted bills, which we hope we can bring to you for your review and consideration. We're also committed. I've served on a number of drafting committees, study committees, and special committees. The other commissioners have heavy loads as well. So far this year, I've spent about 75 or 80 hours on uniform laws, and I share that number with you so that you'll see that I take this volunteer position very seriously, as do my fellow commissioners. When I think about the people who might have received organs because of the revised Uniform Anatomical Gifts Act, who may have been assisted by charities that were able to stay in business because of the Uniform Prudent Management of Charitable Assets Act, who add clarity about the privileged nature of mediation. I feel happy and I feel satisfied that the uniform laws make a difference. So I hope that my nomination will be confirmed and that I'll be allowed to continue my work. And thank you.
Thank you very much. Members, any questions for Ms. Kent? I had a question for you. You described quite nicely some of the stuff that some of the uniform laws you've worked on in the past. What do you look forward to working on in the next, let's see, 4 years?
Okay, well, in the next 2 months, I really hope that the Canadian Domestic Violence Protection Orders Act will be passed out, that parentage will be passed out, and also public participation. Those are 3 that I'm working on for the rest of this session. In terms of the next 4 years, I've been very focused on bringing diverse voices to the table, and that includes community members participating in the drafting process. I hope that we will also focus as a commission on more laws outside of the commercial area. I'm in particular interested in areas outside of commercial, ADR, other issues that affect people and animals. And I'd like to get a lot more really good ideas into the commission so that we hear what are the laws that people are looking for, where we need to have uniformity among the states. So those are the things that I'd like to focus on.
Okay, thank you very much. Members, any other questions? If not, members, unless there's an objection, I'd like to go ahead and vote on the 3 GMs now, just so that those of us who are up for votes from time to time sit on pins and needles until the vote's over, even if you're pretty sure you're going to win. So let's go ahead and vote. Senator Costi, are you okay to play vice chair today?
Yeah.
Okay. All right. First up, we have Catherine Kime for the statewide voter.
Wait, hold
First up, we have GM 595. This is for Catherine Kime for the statewide voters with special needs advisory committee for a term to expire on June 30th, 2025. Recommendation is to get how it's phrased, advise and consent. Members, questions or concerns? If not, Senator Ocasio.
Okay, Chair, we're voting on Governor's Message 595. Chair Rhodes.
Aye.
Senator Keohoko-Olole is excused. I vote aye. Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee.
Aye.
And Senator Favela is excused. Yeah, Mahalo, Chair.
So thank you. Next up is congratulations, Ms. Kime. Next up is GM 590, Dr. Patricia Morrissey for consideration and confirmation of statewide voters with special needs advisory committee for a term to expire June 30, 2025. Recommendation is the same here, to advise and consent. Questions or concerns? If not, Senator Ocasio.
Okay, Chair, we're voting on Governor's Message 590 to advise and consent. Noting the excused absence of Senator Keohoko-Olole and Senator Favela. Do I have any reservations? Any no votes? Okay, Chair.
Thank you.
Adopted.
Thank you very much. Congratulations, Dr. Morrissey. Moving on to GM 635, this is Elizabeth Kent for the Commission to Promote Uniform Legislation for a term to expire June 30, 2026. Recommendation is to advise and consent. Questions or concerns? If not, Senator Ocasio.
Okay. Chair, we're voting on Governor's Message 635 to advise and consent, noting the excused absence of Senator Keohoko-Olole and Senator Favela. Do I have any reservations? Any no votes? Seeing none, measure adopted.
Thank you very much. Congratulations, Ms. Kent. Keep up the good work. All right, members and everyone else, let's go ahead and move on to HB 1777. This requires the Department of the Attorney General to provide annual reports to the legislature on available data pertaining to the commercial sexual exploitation of children. First up on 1777 is Farshad Talebi for the Deputy Attorney General for the AG's office. Good morning.
Good morning, Chair Rhodes, Vice Chair, members of the committee. I'm Fashad Talebi, Deputy Attorney General and State Human Trafficking Coordinator. We're in support of this bill. I believe this committee heard and passed the companion SB 2638. So not going to belabor the point, but we respectfully request you pass this bill, and I'm here for any questions. Thanks.
Okay, thank you very much. Next is Lynn Costales Matsuoka, Associate Director of the Sex Abuse Treatment Center of Hawaii.
Not present, Chair.
In support, Kathy Best, Director, Department of Human Services. In support, Craig Harai, Director, Department of Budget and Finance with comments. Judith Clark, Executive Director, Hawaii Youth Services Network. In support, Chris Cofield, Executive Director, Imua Alliance. In support, Dara Carlin. In support, Andrea Notoskar. In support, and Tamara Swift in support. That's all the testimony we have on HB 1777. Members, any questions for the Deputy Attorney General? Just check here. I think for Mr. Talebi, I think your testimony was that you would need additional funding for the annual reporting. Is that correct? I think you're muted. There you
go. Yes, Chair. There is unspecified appropriation in the bill as written, but we do note that I believe the Senate has passed Bill 2930, and that creates essentially a human trafficking unit. We did get the funding through that bill, then it would account for the work and resources needed for carrying out the duties of this data collection bill. So there would be additional resources needed.
Do you have a number on what that those additional resources would be?
I don't. But I can get back to the committee.
What kind of ballpark range are you talking about? You know, $10,000 or $1 million, or I'm reluctant to leave the blank there. I'd like to put in a reasonable number, but if you don't have one, then I probably will just leave it blank.
I can always use additional resources. Probably on that lower end, though, Chair.
Okay. All right. Thank you. Yes, Senator Gabbard, go ahead.
Yeah, my understanding is that it's very difficult to track the commercial sexual exploitation of children. So how will that data be collected?
As outlined in this bill, and part of our initial testimony in terms of the amendments was to make it a little bit more vague, I guess, or less as a requirement for the other agencies and departments, because it does potentially stress those resources. I will say with the task forces we have, the committees we have, it's been a focus to try and collect data. So a lot of it has to do with implementing certain screening tools, making sure we have consistency, and then for all these different potential points of contact with these victims, and then being able to, have those entities provide it to one source that we can consolidate and then present it as a report.
Okay. Thank you.
I don't know if that answered it.
Yeah, it is. Thank you. Thank you, Chair.
Thank you, members. Other questions? Senator Kim, go ahead.
Well, I'm just wondering as to how effective and how much data we'll actually get and what the cost will be. So is there some kind of evaluation at the end of the period so we can make that evaluation?
So the hard thing is we have to be a little bit proactive with this. It's not data that, again, is just sitting there right now. The data that is available is from reporting either to the hotline or law enforcement. And so, as I mentioned, some of additional resources, if we are able to implement things like screening tools and having a database, that would help us be a little more proactive in collecting additional data. So, you know, more resources means we can expand our ability to collect. Right now, we'd essentially just be trying to pull what is available currently.
No, I understand that, but the fact that just because you get more resources, how effective and how much data are we actually going to be able to get? And at some point, is the amount that we're going to spend in resources going to be worth it as to what kind of data we actually are able to get, even by being proactive? I mean, at some point, you know, if you're not able to collect that data or get the kind of data we hope to get, you know, what kind of return are we getting for the investment? So we need some method of evaluating this so that we're just not throwing money at the problem and not being able to get anything that's going to be of value in getting the data.
Yeah, I understand that. I think we probably could potentially do an assessment of other models from other states or what types of resources are being used there. I will say generally when it comes to trafficking, because victims are reluctant to self-report, it does take the resources on the front end in order to help identify these victims, help investigate offenders. And so it is difficult because we're looking at it saying, well, do we have a problem? Do we need to invest in something? That doesn't look like we have a problem. Where's all your information? But in order to have that information to demonstrate the problem, we kind of need those resources up front to be able to be more proactive.
Mr. Chair, I think if we could put something in here for some sort of report and evaluation. I'm not sure if it's already there, but
we do have. I was planning to recommend that we put in some language on what we're collecting and how to collect it. So I think that gets to your point, but we'll see.
Yeah, we can put some kind of
I
language.
understand what you're saying.
Okay, thank you.
Members, any other questions? Mr. Philby, I do have another one. So there's a term in here, third-party traffickers. Is that a commonly understood term in this world? Does it need a definition? That's my real question.
So I would have to look closer at the bill where it says that, but yeah, I think it's understood that it's not the potential buyer or the victim, but it's the third party that may be profiting off of the trafficking. So
you think it probably does not need a definition.
I don't think so. When I look at the bill, I think the definitions are clear, and we gave our comments initially, and I think the changes that we are concerned about were made. Okay.
Would there be an issue with requiring state contracted providers to collect and report the data specified in the bill? Right now, it's not really clear whether they have to or whether they're just encouraged to.
And that's what we did is we asked that it would be more on the encouraged end rather than required, given we know, they have their hands full with a lot of other things and it potentially would take those resources. So I think the way it's written is kind of that encouragement for people to coordinate and have the end goal of being able to put it in a report that would be available publicly and then, to policymakers.
Okay. All right. Thank you. Members, any other questions? All right. Thank you very much for being here. We'll move on to HB 1423. This increases the fine that may be assessed for campaign spending violations against a non-candidate committee. First up on 1423 is Sandy Ma, Executive Director for Common Cause Hawaii. Oh, Harry, in person. Good morning. I shouldn't be surprised. It actually says in person on my sheet. I just haven't gotten that far.
Good morning, Chair, members of the committee. It's good to see everyone in person after more than 2 years. Sandy Ma for Common Cause Hawaii. We are testifying in support of HB 1423. We think increased fines against PACs and super PACs will lead to more transparency and accountability in our elections. Short testimony, but thank you for opening up the Capitol. Happy to answer any questions.
Thank you. Next is Gary Kam for Campaign Spending Commission. Good morning.
Good morning. Good morning, Chair, members of the committee. I'm with the Campaign Spending Commission and we support this bill. We've been trying to get the increase for fines for super PACs for a while now. We submitted testimony in support. I would just like to say that we request that the committee reinstate the fine amount that the House blanked out and give the effective date a good date. Thank you.
Thank you very much. Next we have Becky Shapiro for League of Women Voters in support, Lynn Mattisau in support, Peter Greenhill in support, David Anderson in support, Kathy Jaycox in support, Lisa Hune-Eller in support, and Lori Boyle in support. That's all the testimony we have on HB 1423. Members, questions? Mr. Kam, I do have a question for you. So your written testimony notes that there's an amendment that affects Liquor Commission employees. What exactly? What does that do? Because it deletes the reference to this other section. And does that mean...
Since I've been with the commission, we've never received any referrals from the Liquor Commission concerning their employees. So I don't know if they have another way of dealing with that, or maybe it's not a problem. So for the Campaign Spending Commission members as well as the staff, the law provides that we cannot get involved with campaigns, and that's pretty easy to comply with. So maybe that's not really a problem with the Liquor Commission staff.
This is an administration bill, right? So why did you guys put that in there?
This is not an administration bill. It's the Campaign Spending Commission supported bill. Our bills don't go through the administration.
Okay, but this is not a bill that you drafted?
It is a bill that the commission drafted, yes.
Okay, so that's why I'm coming back to that point on the Liquor Commission employees. So you have another way of dealing with Liquor Commission employees if they do something on the campaign side that they're not supposed to? Or I'm just trying to figure out what the amendment's for.
It's not something that the commission, as far as I know, has had to address a case involving the Liquor Commission. I mean, if the committee decides to not make that amendment, then it still stays on the books, and I guess we'll wait to see if we get any cases.
Okay, I don't want them to be. Is there some other part of the statute that applies to, or what?
No.
Okay, that's the part I'm a little concerned about. So we have no enforcement power over Liquor Commission employees if they do something they're not supposed to do, or not we, but you.
I suppose one shouldn't be violating the law, right? I mean, it's sort of like with the commission staff, we says that we cannot get involved with the political campaigns, and if we do, it doesn't say that the commission will enforce that mandate. So someone else will have to do it.
All right. Okay. Thank you. Members, any other questions? All right. Thanks, Mr. Kam. Moving on to next bill, which is HB 1426. This provides that a person waives the right to a contested case hearing if the person fails to request a contested case hearing within 20 days of receipt of the Campaign Spending Commission's preliminary determination. First up on 1426 is Sandy Ma of Common Cause. Morning again.
Good morning, Sandy Ma for Common Cause Hawaii. Good morning, Chair, members of the committee. We do support this bill 1426 HD1. We are concerned that it states that judgments of the circuit courts are not appealable. We want to make certain that people may have their rights for collateral relief. Thank you very much, and I'm available to answer any questions.
Thank you. Next is Mr. Cam for Campaign Spending Commission.
Good morning. Good morning, Chair, members of the committee. The commission supports this bill. We've submitted testimony support. I guess the point that I want to emphasize for the committee is that right now the Department of the Attorney General cannot collect commission orders for fines as a judgment, as a money judgment. So the way the statute currently reads, it kind of takes a criminal approach to it, where it's punishable as contempt of court. And so the way the Attorney General's office has been getting compliance is by getting a bench warrant issued with bail set at $500. And that seems a little excessive if we're just talking about an ordinary collection type action. Other than that, I'll stand on our written testimony. Thank you.
Thank you. Next up is Natalie Awasa in opposition. That's all the testimony we have on HB 1426. Members, any questions? Senator Acosta,
yeah.
go ahead.
This could be for Gary Kam.
Yeah.
So is the 20 days too short? Or and I guess as a follow-up, would 45 days still have the same effect?
So the 20 days is not a change in our statute. It's been in our law since well, it has to have been in there since the recodification in 2010. So if you look at 11-405, it has in there that you have 20 days after receipt of the preliminary determination to ask for a contested case. So it's not a change in the law. It's just putting that provision in another part of our law, in addition to 11-405.
Okay, thank you.
Other questions, members? If not, Mr. Kam, so the appealability question. So in this instance, this means that the person who was, I don't know if charged is the right word, was the respondent for the civil fine. Keep coming back to the word charge, the violation or whatever you want to call it. That just means that they didn't fight it, right? They left it alone and said we're not asking for a contested case hearing.
Correct. So without asking for a contested case, there's really no record on appeal for the circuit court or an appellate court to render a judgment. They would just remand the case back to the commission if they felt that there should have been a hearing.
Right. So really, the appeal in that case is asking for the contested case hearing because you're fighting the fine.
Correct. So that would be the first step of an appeal, would be the contested case hearing. And from there, if you disagree with the with the contested case determination, then it's on to circuit court and then on to the appellate courts.
Okay. So just to reiterate, this only applies to people who did not fight the fine. They just said, okay.
Yeah, they don't fight the fine and they don't respond to any type of request that they pay the fine. And there's only, at the most, there's maybe 15 candidate committees that were referred to the Attorney General's office. None of them have been anyone that have prevailed in an election, because if they did, then they would not be sworn in if they have any outstanding fines or reports. So it's a small but frustrating group of people that just don't respond to us.
Okay. All right. Thank you. Members, anything else on HB 1426? Okay. If not, we'll go ahead and move on. Thank you, Mr. Kam. We'll go ahead and move on to HB 1695. This is relating to fireworks, increases from 2,000 to 5,000 maximum fine that may be assessed for certain fireworks related violations. First up on 1695 is Steve Goebel or Wayne Masuda for the Hawaii State Fire Council. Mr. Masuda, good morning. You're still, okay, there you go.
Morning, Chair and committee members. Wayne Masuda on behalf of the State Fire Council. State Fire Council supports HB 1695 and we have submitted written testimony.
Thank you very much. Next is Larry Varai for the chair of the Pearl City Neighborhood Board. Good morning.
Yeah, good morning, everyone. Aloha, Chair Rhodes, and Vice Chair Cascio, and committee members. It's Larry Varai. I'm chair of the Pearl City Neighborhood Board, and thank you for allowing me to provide testimony today on HB 1695. As chair of the Pearl City Neighborhood Board, I'm representing not only our board, but our residents, our families, and pets that negatively impacted by the random, all hours of the day, terroristic, loud aerial fireworks explosions, which impact our lives daily. Our board unanimously approved our resolution on fireworks at our January 25th, 2022 neighborhood board meeting to include a mitigation plan and recommendations for our congressional representatives and state legislators. We strongly support this bill by increasing the fine for illegal fireworks use and the distribution of sales up to $5,000 based on the seriousness of the offense. For example, terrorizing schools, child, adult daycare centers, hospitals, church services, and my neighborhood board. We also understand this bill is meaningless unless there is evidence provided by the community or gathered by the Honolulu Police Department to lead to a prosecution of bad actors where they should be fined appropriately. I most strongly urge you to support and approve HB 1695 HD1. I'm totally confident the community will begin standing up to bad actors, work with HPD, and provide the evidence needed for the court to prosecute and fine. Mahalo, and thank you all for what you do.
Thank you very much. Next is Max Atani, Director for Hawaii Department of Public Safety and Support. Fire Chief Sheldon K. Howe for Honolulu Fire Department and support. Bradford Ventura Fire Chief for Maui Fire Department and support. Kathy Gogol for Animal Rights Hawaii and support. Scott Smart in opposition. Lynn Mattisau in support. Johnny Mayel Perry in support. Beverly Heiser in support. And Gerard Silva in opposition. That's all the testimony we have on HB 1695. Members, questions? It's a pretty straightforward bill. Let's go ahead and move on to HB 2275. This is also a fireworks bill. It establishes an expeditious adjudication system for the processing of certain fireworks infractions. First up on HB 2275 is Tricia Nakamatsu. Prosecuting attorney in support with amendments. Okay, thank you. Next is Stephen Gobel or Wayne Masuda for Hawaii State Fire Council. Morning again, Mr. Masuda.
Morning, Chair and committee members. Once again, State Fire Council supports HB 2275, I believe, and we have also submitted written testimony.
Okay, thank you. Next is Larry Varai. I'm sorry, I don't know how to pronounce your name, Mr. Varai, Chair, Pearl City Neighborhood Board.
Okay, it is Varai, and Chair, I stand by my testimony. It's clearly there. Thank you.
Okay, thank you. Next is Sam Mitchell.
Not present, Chair.
Not present. In support. Michelle Acosta, Deputy Chief Court Administrator for the Judiciary with comments. Craig Harai for Department of Budget and Finance, also with comments. Fire Chief Sheldon Howe for Honolulu Fire Department in support. Bradford Ventura Fire Chief for Maui Fire Department in support. Stephanie Kendrick, Hawaiian Humane Society in support. Lynn Mattisau in support. Johnny Mayel Perry in support. Beverly Heiser in support. And Gerard Silva in opposition. Okay, members, questions on HB 2275? For the prosecuting attorney or his designee. So the bill proposes to institute a minimum weight threshold for the misdemeanor crime of purchasing, possessing, or igniting aerial fireworks. Currently purchasing, possessing, or igniting any aerials is a misdemeanor. But if enacted, violations involving aerials up to 5 pounds would fall under the proposed adjudication system. Do you have any concerns about that proposal?
That would be a policy matter as far as what weight the legislature would like to designate, but we believe the intent is to comport with the changes that are proposed on page 29, lines 3 through 10 or 7, 3 through 7 particularly, where it says that any offenses not having a specific penalty would fall into this fine
Okay, so but for essentially some of these violations or again, that violation is a technical term in the penal code, but violations or offenses, that would actually be lowering the severity of the offense. So I just want to check and see if you guys are okay with that.
Yes, and as we pointed out in our written testimony, it does seem counterintuitive that the Department of Prosecuting Attorney would be on board with decreasing the penalties for a problem that we realize is very pervasive, has become as bad as it has been in particularly at New Year's time. Was very clear to see just how bad it's become. However, due to certain considerations in court in trying these cases, evidentiary considerations, we believe that this frankly is worth a try.
Okay.
It would help. Could help.
Just want to check. Thank you very much. Members, any other questions? Thank you. Thank you, Ms. Nakamatsu. We'll go ahead and move on to the next bill, which is HB 1541. This clarifies acceptable procedures for initiating criminal complaints. First up on 1541 is Prosecuting Attorney Alm, and you are here. Good morning.
Good morning, Chair Rhodes, members of the committee. Pleasure to be back in front of you. We stand in support of this. Frankly, it's somewhat of a chaotic situation in our courts. And with me here today are the two division chiefs for the two divisions that are most impacted by this, Florence Nakakuni and Tiffany Kaeo. Over 1,000, or just about 1,000 cases have been dismissed so far. When the Supreme Court came out with its ruling, as Supreme Courts tend to do, it's very narrowly drafted. It applies to that case. So the question is, does it apply to other things, what the rules are and the like? And we've tried various things in the different courts, but there are 25 different full-time and per diem district court judges. The rulings, frankly, are all over the map. What one judge will say is okay, and another judge will say it's not. So, and this does include sex assaults, domestic violence cases, TROs, OVUIIs, and other kinds of cases. So we're coming to you for help. Cases are being appealed, but it's likely to take a few years to get the results in that, and that may be another narrowly drafted ruling. So trying to find out exactly what to do is challenging. So we believe this bill does it, and I thank you for giving me a chance to address you.
Thank you. Thanks for being here.
Thank you.
Next is Archie Cole for Mothers Against Drunk Driving. Good morning.
Good morning. Thanks for allowing me to testify. It's exciting to be here in person. I'm all nervous. The bottom line for us is that it's this confusion that Prosecutor Almer was just referring to among law enforcement, the bench, and others arising from that decision in December. State v. Thompson has resulted in 1,000, I now understand. I wrote here hundreds of dismissals of impaired driving cases and domestic violence and other criminal cases. I just want to say that speaking from the standpoint of the victims, because that's in our case, that's what Mothers Against Drunk Driving Hawaii, we represent the victims of these crimes. And many of these are actual crimes against victims, clearly domestic violence, but also in the case of drunk driving, that this is causing anguish, these types of suddenly learning that the person who ran over your daughter is now had his case dismissed, is a real cause of anguish, and we ask your help in going along with this, with passing this on. Thank you very much.
Thank you. Next we have Amy Murakami, Deputy Attorney General. Good morning.
Good morning, Chair Rhodes and members of the committee. Thank you for allowing the department to testify on this bill. The department supports the passage of this bill, which amends 8051 to allow prosecutors to initiate a complaint by just their signature. This amendment addresses the confusion that was an inconsistency that resulted from the ruling in State versus Thompson. And it provides a simplified process without reversing the substantive rights of defendants. Prosecutors still must comply with their ethical duty to only charge cases that are supported by probable cause, and the defendant's constitutional rights to confrontation at trial are not adversely affected. And for non-felony cases, the defendant's right to a judicial determination of probable cause, which only exists when the prosecutor is either seeking a warrant of arrest or is initiating the complaint and the defendant is in custody. These safeguards and requirements are still in place and will not be changed by allowing the prosecutor to initiate the complaint without a signature of another person. Therefore, the department respectfully requests passage of this bill, and I'm available for questions.
Thank you very much. Thanks for being here today. Next is John Ikenaga for the Office of Public Defender. Good morning.
Good morning, Chair Rhodes and committee members. The Office of the Public Defender strongly opposes House Bill 1541 for the reasons set forth in our written testimony. I would note that in response to Prosecutor Alm's comments, that the majority of the dismissals in these cases are dismissals without prejudice. So the impression that there's 1,000 cases that have been dismissed and that these cases are forever gone is misleading to this committee. We believe that the statutory requirements are clear. There is no need for clarification, which is the supposed purpose of this bill, when in fact, what the bill is seeking to do is circumvent what the original purpose in enacting 805-1 was, which was to allow the accused to confront the veracity of their accuser. Our position is that the prosecutor cannot be the accuser because he is not the witness nor the victim in the case. So again, we strongly oppose this bill, and I'm available for questions if necessary.
Thank you very much. Thank you very much. Next is Rebecca Leakey for the acting prosecuting attorney for Kauai. Good morning.
Good morning. Good morning, Chair Rhodes, members of the committee. Thank you for giving me the opportunity to testify this morning. I wanted to appear to show my support for House Bill 1541, and I'll rest on my written testimony that I submitted on behalf of our department, and I'm available for questions.
Thank you very much. Next is Keldon Wallian for Hawaii County Office of the Prosecuting Attorney. Hey. There you are. Good morning.
Good morning, Chair Rhodes, members of the committee. Hawaii County Prosecuting Attorney Keldon Wallian, testifying in strong support of House Bill 1541. We stand on our written testimony. We share in the same concerns that were shared by Prosecuting Attorney Alm and Leakey and Deputy Attorney General Murakami. I'll be available to answer any questions that you may have. Mahalo for the opportunity to testify on this matter.
Thank you very much. Next is Andre Peters, Acting Captain, Traffic Division for Honolulu Police Department.
Not present, Chair.
In support, Andrew Martin for Maui Department of the Prosecuting Attorney. Good morning.
Good morning. Good morning, Chair Rhodes, committee members. Thank you for the opportunity to testify. We are testifying in strong support of the bill. And as was pointed out previously, the Thompson decision's lack of clarity with respect to how this antiquated statute, which dates all the way back to 1892 in its first iteration, is to be applied, has created a good deal of disparity, not only among the circuits, but within each circuit among individual judges. And that is just a way that the criminal justice system cannot continue to operate. Depending on, first of all, which circuit you live in, and then within each circuit, depending on which judge your motion is in front of, is dictating how these motions are being ruled on because of the lack of clarity in who needs to sign these complaints and what the appropriate procedure is for. This bill provides clarity, will dispense with that disparity among the circuits, among individual judges, and will provide enough much needed relief in that respect. It'll be in line with changes the Supreme Court made in 2008 to the White Rules of Penal Procedure. And if I may respectfully disagree with Mr. Ikanaga on the argument that this statute was enacted to provide the defendant with an opportunity to challenge the veracity of the complainant, I don't think there's anything in the legislative history to support that interpretation at all. The opportunity to challenge the veracity of the complainant occurs at trial. This bill and its iteration does nothing to prescribe or restrict the defendant's right to confrontation, to compel witnesses to testify or testify in his or her own behalf. And therefore, their substantial rights are not impacted in any way whatsoever. Thank you.
Thank you very much. Next up is Angelina Mercado, Executive Director of Hawaii State Coalition Against Domestic Violence. Good morning.
Good morning, Chair Rhodes and committee members. I'm Angie Mercado, the Executive Director of the Hawaii State Coalition Against Domestic Violence. We stand on our written testimony in support of HB 1541. And given the number of cases that are being dismissed due to the lack of guidance on the Supreme Court's recent decision, we respectfully ask the committee to please pass this measure. I'm available for any questions you may have. Aloha.
Thank you very much. Next is Nancy Creedman for the Domestic Violence Action Center in support, Paul K. Ferreira for Hawaii Police Department in support, Tina Yamaki for Retail Merchants of Hawaii in support, Director Jade Butai of Department of Transportation also in support. That's all the testimony we have on HB 1541. Members, questions?
Sure. I have a question.
Senator Casio, go ahead.
Maybe for Mr. Alm. Just wondering if there are procedural safeguards or independent review to ensure the veracity of these charges.
Right. Well, that's what the trial is for. As was pointed out, the confrontation clause comes up at trial. The purpose of any criminal complaint is to tell the defendant what charges are against them and what's being brought. That is still provided with this.
Mm-hmm.
The problem with the decision is it says a declaration, but not by whom. And it's very unclear. And as far as the question about being dismissed, it is without prejudice, but that means we can bring it back. We just don't know how to bring it back that will satisfy the judges. And we've asked them that, and they of course don't tell us because they don't know either. Mm-hmm. They're trying to read the tea leaves from the Supreme Court opinion. Mm-hmm. But all the procedures are in place. Nothing has changed with that.
And it's your position then that it does not negate or get rid of constitutional safeguards?
Absolutely not. You know, prosecutors have to stand behind every case that they bring forward. And that applies here. It applies throughout. As was pointed out, this is a 130-year-old statute that talked about back then the prosecutor examining the complainant. You know, like that has not happened. You know, we don't sit there and cross-examine that part of it. We listen to what they say. What does it make sense? Can we prove a case beyond a reasonable doubt? But it doesn't take any protections away.
Oh, okay. Thank you.
Thank you.
Chair.
Thank you, Senator Kim.
Yeah, thank you. Thank you, Prosecutor. So I'm not an attorney, but can you explain what was the process prior to Thompson, State versus Thompson? And how did you handle it then? And what makes it different now?
Okay. Thompson speaks to a penal summons case. So if a police officer sees, say, a misdemeanor crime committed in front of them, mm-hmm. they will make an arrest. Mm-hmm. If they don't, they will take statements from different people. Say somebody goes into ABC stores and steals from them, runs out. The ABC stores aren't going to fight them. You know, they don't have security guards. They call the police come, they'll take statements from people and maybe do follow-up. Those statements will get sent to our office, typically to Ms. Nakakuni's section. They will review those statements, and then we will sign a complaint in district court, bringing the charge there and informing the defendant of what the charge is against him. So that was signed by a prosecutor. And that has been the process forever. And one of the challenges here is Thompson speaks to a penal summons case. And that's what that is, right? It's if we sign the complaint, take it to court, they will issue a summons. It's served on the defendant to come to court to answer to the charges. And one of the challenges with Thompson is that has now been expanded to include arrest cases, cases where people are in custody, which we think go far beyond what was there before. But the process was a prosecutor signed it based on the statements of the witnesses. If we thought we could prove the case beyond a reasonable doubt, we would bring the case to district court with a prosecutor signing it. And the Supreme Court said that's not good enough. It has to be signed by somebody else, whether it's the victim of a domestic violence case or a police officer. It's unclear whom, but they said the prosecutor's signature was not enough.
And you have trouble getting a signature.
Right. We don't want to go back to a domestic violence victim after paperwork has been filled out in a statement to try to get her to sign it again. It's too dangerous for her. Once the event happens that night, you don't want to have to go back and try to get in touch with her and see if we can go past the abuser to get her to sign it.
Why do you have to go back if they already signed it?
No, they haven't signed it. The defendant gets arrested that night, and then we'd have to draw up the paperwork for it and then have her sign the complaint for court. That's a separate process from her making a statement at the scene.
What happens if a complainant does not want to file any charges?
Well, we have totally revamped our domestic violence processes. It used to have a rigid no-draw policy for the last 30 years. And so now if a complaining witness, say a victim in a domestic violence case, does not want to pursue the charges, we're actually not proceeding with it. We're working with Nancy Kriegman and to work on services for the victim. But now if they don't want to sign it or proceed, we don't even proceed with the case anymore because we're listening to, it's her, it's not always her, it's sometimes him. But they're in the best position to know how dangerous their situation is. Are they going to get beat up if they testify? That kind of thing. So in that case, we don't even proceed with the case anymore.
So is there any way to narrow this measure to address Thompson and not affect everything else?
I think it's what's done is really elegant. It's adding, as has been done in Rule 7 of the Hawaii Rules of Penal Procedure, that allows the signature from a prosecutor on a complaint. This is going to do the same thing.
Mr. Chair, can I ask a question of the
please go ahead.
public defender? Thank you. You can stay there. There might be other questions.
Okay.
Public defender?
Yes.
Yes. Can you respond
To, I'm sorry, which
to the process that has been in place and now? And
well, the Thompson clarified the requirements of HRS 805-1, which were always in place. So prior to Thompson, it appears that the state, just going by the prosecutor's signature, was not meeting the requirements of 805-1. So it took a challenge by an attorney on the Big Island to bring this to light. The prosecutor is saying that this is a clarification in some ways, but it actually goes contra to what 805-1 clearly says, that it has to be the accuser who signs off on the complaint. I also wanted to respond to Mr. Martin's comment earlier. In Thompson,
I'm sorry.
actually,
Senator Kim, do you want to hear this answer? Okay, go ahead.
Thank you.
I'm sorry. In Thompson, the Supreme Court cited the legislative history behind the 2007 amendments, I guess, to 805-1, and stated that one of the purposes of the statute was to allow the accused to confront the veracity of the accuser. So that is, in fact, contained in the legislative history of the statute. Is there anything else you would like me to respond to, Senator?
but they can get that veracity during court hearing, right? I mean,
of course, but initially, what happens is that if the complainant is required to sign off on it, and I believe this is the reason the requirement is for the complainant. I mean, in cases where, for instance, a DUI case where a police officer is the only witness to the offense, the police officer could be the witness in that case. However, in a conventional case, let's say an assault, where there's a distinct victim, When a person makes allegations which create the stigma and expense, the issues associated with being accused in a criminal case, we believe the statute's purpose was to compel this person to stand behind those allegations and subscribe to the complaint, either by signing the complaint under oath or affirmation or by declaration in lieu of affidavit. The Honolulu Prosecutor's Office in FCCR cases has begun to attach the discovery, which contains the complainant's statements, which are HPD 252 form, which is signed under oath, and also the police reports, which have I believe, an oath at the end of them. So they are taking steps to meet the requirements of the statute.
Thank you. Can I do one last question?
Yeah, go ahead. Go ahead.
So other than a domestic violence situation where the claimant may not want to complain or would not want to sign, or you have difficulty, what other situation would then you're not able to get a signature? In a DUI case, the officer would sign it. In a theft case, the store would sign it.
But what it would mean would be going back and finding the witness after the complaint had been drafted and getting them to sign it at that point. And so it's another layer.
Well, why wouldn't you have them sign it right at the scene?
Because that's a statement they're making. It's not a formal complaint that's going to get filed with court.
Couldn't you just have a form that says I'm the complainant and have them sign something?
That's not what's needed for the court.
Well, but what we're saying that it's not defined, so shouldn't we define it as such?
It allows alternative procedures for it to be filed, either subscribed under oath by the complainant, which means a notary public, or made by declaration in lieu of an affidavit. And who that declaration is, we don't know. The Intermediate Court of Appeals, that's what we had been following initially, had said that they said it was okay. And that the crucial element for initiating and maintaining the prosecution is the prosecutor's signature, because we're evaluating and we're having to stand behind it to bring it into court. So whether it's a police officer, whether it's a victim, whether it's a ABC store employee, we're standing behind it and we're the one bringing the charges as the state of Hawaii, not an individual person.
Okay, I can understand that. And I'm just concerned as an individual, if I've been charged with something and the complaint is, just because you don't want to go after getting the signature, and then the cost for me to have to go to trial, so I'm looking at it from that point of view.
Well, we're standing behind it by filing the complaint, and this would allow that to take place.
Right, but then you weren't witness to my violation.
No, but we're reading the reports.
Members, other questions? I do have a couple myself, but for Mr. You can still stay there if you don't mind. Ike Naga, for Mr. Ike Naga, sorry.
Yes.
So you testified that the words of the statute remain the same, which is true. They have remained the same, but the interpretation has changed rather dramatically, it looks to me like. So my question then is, does this bill, do you think this bill takes us back beyond Thompson? Does it take us just back to what you could do before Thompson, or does it take us farther than what you could do before Thompson?
Well, I think it's contrary to the intent of the legislature.
No, because for years and years, they basically, the procedure that the prosecutors are asking for was how you got cases started. So they're saying, and I'll ask the prosecutors next, but my understanding is what they're saying is take us back before Thompson to the interpretation of the statute that was in place for years before Thompson. Are you arguing that this is more than the pre-Thompson interpretation?
Well, the statute, I believe the statutory requirements were clear.
Clearly they weren't. They clearly weren't clear because one judge said one thing and one judge said another. So,
Well, the procedure wasn't challenged before Thompson, to my knowledge. There were, I'm not aware of any appellate cases where an attorney had challenged the requirements of whether the prosecutors met the requirements of 8051. So sometimes that's what it takes. You know, a statute will just sit on the books.
I understand that. I don't think I don't know if you're not answering my question. The question is, do you think that this bill takes us back to the pre-Thompson interpretation of the statute? I realize the statute has not changed and that it's never been challenged and the Supreme Court can do whatever they want in terms of statutory interpretation. But as a practical matter, does this bill take us back to pre-Thompson or does it do something else?
Yes, I believe it would take us back to the procedure that the prosecutors believed was valid prior to Thompson, the Thompson opinion.
Okay, fair enough. Thank you. For the prosecutor, so we've already gone over the fact that most of these are, okay, so what's going to happen? The same question, I guess, first that I just asked Mr. Okinaga. Is this going back to the pre-Thompson interpretation or is this doing something different?
Yes.
It's only, that's.
And the procedure that have been in place for decades.
So, I mean, the concern I would have is if we're carving out more space in it,
these are how complaints have been brought for decades.
Okay. All right. Then on a separate line of questioning, what is so all these cases that have been dismissed with prejudice.
Without
prejudice, yes. You're going to refile as many of them as you can. What happens between, I mean, this bill hasn't passed yet. So all those cases between Thompson and when this bill, assuming this bill passes,
we would try to refile in the best way we can guess will be accepted. What we're doing now is we're getting different results with different judges, but we will do our best to try to do it. I don't think we can go after, go to victims in certain cases, but we will do our best to refile as many as we can.
But this bill, there's no attempt in this bill to make this retroactive, no. Right? This is only from the point that it passes on.
Yes.
Okay. All right. Anything else, members? If not, I think we're done with the, thank you very much for being here. Unless members feel the need to go into a breakout room, not breakout room, into a private conversation. You want to, okay. We'll go ahead and recess for decision making. Okay, back in for out of recess for decision making on part of today's agenda. We've already voted on the 3 GMs. So we'll start with HB 1777. Relates to the commercial sexual exploitation of children, requires the Department of the Attorney General to provide annual reports to the legislature and available data pertaining to the commercial sexual exploitation of children. Recommendation here is to pass with some amendments. I'd like to change the reporting deadline to 40 days prior to the start of the legislature session instead of 20, and add a requirement that the AG, in consultation with the Department of Human Services, develop guidelines for data collection, data sharing, and data reporting. It's a little squishy on who's collecting what from whom, so we'd like to have them consult and figure out what the best course of action is. We'll require the AG to post the reports on the AG's websites. We'll specify that the state contracted providers are required to collect and report the data specified in the bill, and clarify that references to entities willing to collect the data does not include state contracted providers, since we've already covered them elsewhere. And then there's some SMA text.
We put in some kind of evaluation report.
Oh, okay, I'm sorry. On the fourth one, we'll specify that the state contracted providers are not required, but that they are encouraged to collect and report. Yeah, so that's, yeah.
We put in some kind of evaluation.
Well, I think the evaluation would come with the rules on how to what and how to collect the data. Yeah, I mean, we
that's
can,
one thing, but to the fact that if, say, at the end of a year or 2 years, that we haven't really collected any valuable data because we just couldn't collect it, and that, you know, we're spending thousands and thousands of dollars and it continues to go on.
yeah, no, it's a point. Let's see, if we, well, we could just make it a pilot project and run it for 5 years and see what happens.
Okay.
All right, we'll make it a pilot project and just try it for 5 years and see what we get, and then reevaluate at that point as to what we need to do or not do. Okay, any other questions or concerns on SHB 1777? Seeing none, Vice Chair for the vote.
Members, HB 1777 HD1 passing with amendments. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee.
Aye.
Senator Favela.
Aye.
Chair recommendation adopted.
Thank you very much. Next up is HB 1423. This increases the fines that may be assessed for campaign spending violations against a non-candidate committee. Recommendation here is to go ahead and reinstate the $1,000 fine, change the date to effective upon approval. And we'll take out the amendment that the Campaign Spending Commission had on the Liquor Commission employees. I don't quite understand what they were trying to do, and so I'm going to just take it out for now. Questions or concerns? If not, Vice Chair.
Members voting on HB 1423 HD1, the chair's recommendation is to pass with amendments. Noting the presence of all members of the committee, are there any members with reservations? Any in opposition? Seeing none, Chair, all members vote aye. Recommendation adopted.
Thanks very much. Next up is HB 1426, provides that a person waives the right to a contested case hearing if the person fails to request a contested case hearing within 20 days or receive the Campaign Spending Commission's preliminary determination. Our recommendation here is to make it effective upon approval, and we'll put in the committee language why the final order is not appealable, because what it means is that the person didn't contest it, and so there's no record on appeal. And I would also note that the Campaign Spending Commission says there is a way to collaterally attack the judgment if new information becomes available or anything like that under, I think it was Rule 60. Okay, questions or concerns on that one? If not, Vice Chair.
Members, HB 1426 HD1 passing with amendments. Noting again the presence of all members of the committee, are there any reservations? Any no votes? Recommendation adopted.
Thanks, members. Next up is HB 1695. This increases from $2,000 to $5,000 the maximum fine that may be assessed against certain fireworks-related violations. Recommendation here is to also increase the maximum penalty for homeowner violations from, I'm sorry, this is for property owner violations where somebody is letting somebody else shoot the fireworks off. So that would increase the fines there from $2,000 to $5,000, and we'll make it effective upon approval. Questions or concerns? If not, Vice Chair.
Members passing with amendments, are there any reservations or no votes? Recommendation adopted.
Thank you. Next up is HB 2275. This establishes an expeditious adjudication system for the processing of certain fireworks infractions. Recommendation here is to move the adjudication system for fireworks infractions into Chapter 291D, which is the same chapter that we already use for traffic and emergency rule citations. Make it effective upon approval. Plus, we'll set at $500 the fine for any fireworks violation covered by this bill, including landowner's liability. And we'll leave for the criminal penalties, we'll leave the criminal penalties alone, so that the more serious fireworks violation could still be prosecuted under the criminal code. Questions or concerns? If not, Vice Chair.
Members, HB 2275 HD1 passing with amendments. Are there any reservations or no votes? Recommendation adopted.
Thank you, members. Finally, we have HB 1541. This clarifies or changes the acceptable procedure for initiating criminal complaints. The recommendation here is to go ahead and pass it as is. And I'd like to bring some committee language indicating that it's the committee's belief that this bill takes us back to the pre-Thompson decisions interpretation of the relevant statute. So that we're not expanding or contracting the previous manner in which you can bring a criminal charge, but just restoring it to the pre-Thompson situation. That's in the committee language. Questions or concerns? If not, Senator Keokalole.
Members voting on HB 1541, the recommendation is to pass unamended. Are there any reservations or opposition? Recommendation adopted.
Thanks very much. Nice to see you all in person. We're adjourned.